What's up, everybody? And welcome back in to another episode of The Lawyer You Know. And we have a lot to talk about in this Brian Kohberger update. It's been a little while. A lot of things have happened, and we are going to try to hit all of them in today's video. It may be a little bit longer. Go ahead and throw your questions in as we go. I'm going to try to be in the live chat as the video is playing. And if you have questions in the comment section, make sure you hit that like button as well. If you continue to be interested in this topic and in this information, because I've gotten sent so many things, and then there's been some new court filings, and we're going to try to hit them all. First, we have the body cam footage of a traffic stop with Brian Kohberger prior to any of this stuff happening that some people seem to think is relevant. I haven't watched it yet. We'll watch it, see if there's anything relevant to this crime on there. Number two, we have the body cam footage executed for the search warrant, which I have heard is basically a nothing burger, but we're going to watch it here together and see if there's anything on it. Third, we've got another set of body cam footage from Xana Kernodle, one of the victims in the case. Again, a house party, noise complaint around the similar time periods to some of the other ones we've watched with some of the other victims, just to give us an idea of the people, how loud it was, what it was like there. And I think that is relevant, or at least could be relevant to the defense's case, that so many people are in and out of there. Maybe that's why his DNA is there. Who knows? But it is potentially relevant. So we're going to watch that video together. And then we're going to go through a few court filings. Some supplemental discovery requested by the defense. They want more stuff. Then a motion to compel. They are arguing that the state is either refusing to give them certain documents or certain evidence that they believe is relevant and should be produced during discovery. Either they're refusing to, or they just haven't gotten to them yet within the time period allotted. So the court needs to force the state to turn over this evidence, or the state needs to file objections so the defense can know why they're not producing it, so we can have a hearing if we need it. And then lastly, an order and notice of hearing that's different than the May 22nd hearing dealing with the non-dissemination order. Excuse me. So a lot to get through. And let's start it off with the body cam footage of, let's start with the search warrant of his apartment. Okay. We all know about this search warrant. We all know and talked when it was executed. So let's look at what is actually shown in this body cam footage.
Yeah. Police department search warrant. Come to the door. Police department search warrant. Come to the door. Good. One more. Police department search warrant. Come to the door. Open the door and do an announcement.
So I will say, we know this is early morning hours, so they're probably sleeping. That's why they're not coming to the door, probably not trying to hide something, number one. Number two, the police definitely knocked and announced themselves before blowing through this door and causing all this damage. Oh, actually, this isn't of the house. Sorry, this is of his apartment, so he's not there. He's at the house. So nobody's there. That's why they're knocking, can't get anything, and they got to get in.
Police department, show yourself. We have a search warrant for the building. Police department, show yourself. You're good, dude. Go back inside. Yep. No. Light, flashlight? Flashlights.
All right.
So that is basically the footage. I think it's blacked out for the most part, but let me see if they show anything else.
Talbot, the bedroom door is locked. He wants to boot it.
Yeah.
Okay, so this is another interesting fact that I heard. Kohberger's actual bedroom door is locked. I don't know if he had a roommate. some of you may know, and you can put it in the comments if he did. And I have heard a big deal be made about this, and it very well could be that he was keeping his door locked, making sure nobody could get in. I do have 2 thoughts on that, however. Thought number 1, when I was in college and we had an apartment that had a shared living room, and my wife, same thing, everybody would lock their own door because that was like your private space. And then you had the shared space, kitchen, living room, TV room, things like that. So it's not that unusual that it's locked because he's still in kind of a college atmosphere, number 1. Number 2, if he thought locking the door was going to keep cops out of it, that's not the smartest thing I've ever heard.
You need anything in your clipboard?
No, I'm good. He's got it. Thank you, guys.
Just the one locked door?
Yeah,
Yeah.
and we didn't boot it because the keys actually worked. What?
Oh, sweet. Oh,
So they didn't have to boot it because the keys actually worked. They didn't have to blow through the front door because they had the keys. That's what happens when you live in an apartment building. The apartment complex can give you a key to any room, so you don't have to go blowing in doors like they did at the house. They didn't have a spare key to the house. They probably knocked. I don't know if they did actually because there were safety issues and they knew that they were in there. So I don't think they actually did knock. I can't remember. We read through that together. I'm sure you all remember. But here they knocked. They announced themselves. It was loud. Nobody was there. They used the key. The door to Kohberger's bedroom's locked. They don't have to boot that door either. They use the key.
It's locked because there's only one occupant.
Today we're gonna.
I'll talk later. Yeah.
I'm just gonna do a quick walkthrough, see what we can see. Are there lights on in there?
There are some. Yeah. And we can turn them all on. Very sparse. Fancy computer.
Really?
Yes.
Oh, fuck. That I wasn't expecting. That's Mallory's gonna be all over that.
Fancy.
So he was told he could do a triage here, and then once he packaged, he can't do anything until we get a warrant tonight, of course.
Correct.
So he can triage it while we're still here.
Yeah.
Okay, so there you go. Talking about the bedroom door, Brian Kohberger's bedroom.
All right. I haven't watched the whole show. I'm sure they think that the fact that his bedroom door is locked means that he is guilty. And again, it could mean he was hiding something. It could mean that he had a roommate that he didn't want to get in there, right? It could mean a lot of things. But that's the search warrant of his apartment. That's the body cam footage. We don't know a whole lot. We do know the bedroom was locked. We do know they found computers. We do know they had keys, so they were able to enter. That's about all we know from that. So next, we're going to transition into a traffic stop of Brian Kohberger. Again, before the crimes occurred, but let's see if there's anything relevant here that we can find out and that may come in at trial or may be relevant to this case or these charges.
Hello,
Officer.
I am Officer Langus. Stops being audio and video recorded. I think you know why I stopped you. You ran the red light.
What actually happened was I was stuck in the middle of the intersection.
Yeah,
So
I was
forced
behind
to
you the
turn
whole
left.
time. Yeah.
Yeah.
So technically, you're not supposed to enter the intersection at all for that reason. Because if the light turns red, then you're stuck in the intersection, and then you run.
So it seems like, and again, this was 10/14 of 22. So right before the crimes occurred, basically. So in timing, it's pretty relevant. But what's interesting about this is he does what a lot of us have done. Put in the comments if you've ever done this, where you go to kind of the intersection, you wait for the light to change, and then you make the left turn. And it seems like he got stuck there and then had to go when it's on red. And apparently he's going to get a ticket for that.
On the red light. So that's the reason I stopped you. Do you have your license on you?
Yep.
By the way, we do see it is him. He's in the white Elantra on the campus.
Do you have the registration and insurance?
They must really be searching if they're pulling people over for this.
Let me just get this for you out.
You what?
I'm just gonna get this out for you.
Okay.
He is being very cooperative with law enforcement, giving them everything they're asking for. No issues there.
So would you explain that to me a little bit further? So in Pennsylvania, when you're stuck like in the intersection, you have to make the left. So what would the appropriate thing for me to have done? Been?
Not-
Just
You're
Back up
not
in
supposed
the
to.
So this is interesting to me because he wants to talk to her about the law. Is it illegal? Not argue with her. He's being very respectful and polite, but he is basically making a bit of a case saying, what was I supposed to do? I was stuck in the intersection, light change. What should I do if this ever happens to me again? Because where I'm from in Pennsylvania, what I did is what you're supposed to do.
That block an intersection like that in Washington. So just by you blocking the intersection, that's technically a ticketable violation. And then then you're running a red light. So it's another ticketable offense. So you're not supposed to proceed into the intersection until you can go. Because a lot of people do what you just did, right? Is like you're sitting in the intersection waiting and then turns and then you're blocking. So
Yeah, there was a little bit of confusion with speeding because someone had stopped. I wasn't sure what they were doing, and then they put on their light to turn. So I thought that.
So he's saying he thought he could go, but then in an abundance of caution to be a safe driver, somebody else was there in turn. He thought they weren't going to. So then he stopped. So now what is he supposed to do? He kind of makes a good point here, I guess, but whatever.
Thing to go through.
Oh.
Did you see that?
No.
I feel like right before I made the turn, there was someone who made a right. They didn't have their signal on, so I wasn't sure if they were just waiting.
Yeah, so I would just advise just don't enter the intersection until you can go so you don't get stuck.
Doesn't sound like she's going to give him a ticket, actually. It doesn't sound like she's that mad about it, but I don't know why she pulled him over for it.
Let's see.
But in that situation, the best thing to do then would be back up. And not.
I don't know if there's a best thing to do in that situation because you're either going to back up into somebody or you're going to run a red light. So, or you're going to be sitting in an intersection.
Yeah.
There's not really a great option there.
Yeah, I was just slightly into the crosswalk, so where I'm from Pennsylvania, we actually don't have like crosswalks.
Oh,
so even if you're kind of slightly, there's a little bit more leeway as well. Like there are a few lines, like there's one white line and there's another one in front. Like there's like a certain.
Seems like he knows the rules, and he is not afraid to discuss it with law enforcement. He's pretty confident in this situation. He doesn't seem scared. He seems like he does want to make his point, and he thinks he's right. A little indication. It doesn't seem like he's going to represent himself, but if he was going to, it seems like he's got some competence there, especially compared to some other people we've seen represent themselves. I just think it's an interesting discussion point.
Yeah.
Not to say that he's going to.
Kind of place your vehicle.
Yeah. So I know laws vary state to state, but there is a law in Washington for blocking an intersection like that, proceeding through when you don't when you're just stalling. I forget the actual verbiage. I can find it for you, but it's like stalling, blocking an intersection.
Cop doesn't know the verbiage.
I'm just curious about the law. I don't mean to.
Oh no, yeah, I can find it for you. Yeah.
Anything.
1 second.
And again, he's just interested. He's just interested in it, which is what a lot of people are saying about him and, his studies and his personality. So that's interesting to me.
That looks good on a Hyundai. I don't see Pennsylvania registration like at all. Okay, let's see. Expires November 22nd or 2022. Okay.
This cop is kind of like, just like the expires November 22nd. Oh, 2022. I don't see where there it is. And we already know that about his registration because he changes it. Remember, there was all that talk and stuff.
Yeah. Okay, that looks good. I'll hand that back to you. I'm just going to go check your info. I'll try to find that RCW, the law for you, and I'll be right back.
Thank you.
All right.
It does not seem like she's going to give him a ticket now. First, I thought she was.
First of Washington.
Skip through this while she looks through. Does whatever she does. You ever wondered what cops do when they go back to their car? Sometimes they're looking up statutes to tell you what you did wrong. Maybe print him a ticket if she's going to give him one. All right. There's the white Elantra.
Okay, so I found it. So I don't know what in Pennsylvania where you go to find laws, but in Washington it's called the Revised Code of Washington. So I'll try to turn my brightness up, but it's just called an RCW. So it's RCW 46.61.202. So it's no driver shall enter an intersection unless there is significant space on the other side of the intersection. To accommodate the vehicle he is operating without obstructing the passage of other vehicles, despite any traffic control signals.
Makes sense, right? Can't block the intersection, can't run a red light. We all do it. We've all done it, but makes sense that it wouldn't be something that you should do or that would be okay to do. And technically you can get a ticket for it. Now, I will say the running the red light is probably the bigger problem, but if you do it without having any issues, as it's like going from yellow to red, it's kind of like Bush League to get pulled over for it. But technically speaking, it's appropriate.
Signal indications to proceed. So you had a green light, so you're thinking you can go, but you're blocking the intersection.
And if you
so
cause an accident or somebody to get hurt by doing it, you should get hammered for it, right? I mean, that's the point, is you should get hammered for it because that's absolutely negligent. So again, seems like he navigated it without any issues, but
that's if you're ever curious in any laws in Washington, just revised code of Washington. So I'm not writing a ticket or anything like that today. I understand you're from Pennsylvania, but in the future, don't proceed through the intersection. You can't get stopped for that alone unless you can clearly just clear it right away.
Okay.
So
So then basically, I understand.
you're just supposed to wait behind the white line. Drivers do it all the time,
It
but
never even occurred to me that was actually something wrong. But
yeah.
well, except for the fact that I was blocking the crosswalk, which is what
Yeah.
I went through.
And states vary a lot from laws. Like Pennsylvania might not even have that law, but in Washington we do.
I'm actually just from a very rural area,
Mm-hmm.
so we just don't have crosswalks.
Oh,
Unless I visit an area where there are crosswalks,
Gotcha.
and then it's not very frequent.
Yeah.
I do apologize if I was asking you too many questions about the law. I wasn't trying to
no, not at
seems like polite, and he seems a little quirky, but seems polite. I'm not sure. I believe him that there's no crosswalks anywhere, maybe in his rural area, but I thought he said Pennsylvania at first. I was like, that would be weird.
all. Like I understand you're not from here, so if you don't, a lot of people don't know a bunch of laws. Like I only know it because this is what I do. But
And even
Yeah.
she didn't know
If
it.
you're ever
Like, I only know it because this is what I do. It's like, but even you didn't know it. So
on any more laws, just RCW, and they can be hard to read because it's in like legal language. But hope that helps.
definitely,
Yeah. Have a good day.
definitely you too.
Thanks.
So no ticket, and he probably would be able to read it because he takes criminology and studies that type of stuff. All right, on to the next video I was sent, which was Xana Kernodle handling a noise complaint, much like her roommates have in the past that we have watched. So let's take a watch and listen to this one together. Pretty loud.
Turn the music down. Turn the music down.
I mean, it doesn't seem like crazy. It doesn't seem like anybody's doing anything crazy right here, but the music is loud. They can't even hear the cops yelling at them. There's some people on the back porch.
Hey guys, second time. I need somebody to come to the door.
Yeah, it's the second time.
Music stays off. Party's over.
It looks like it's 12:36 in the morning on September 2nd.
Here.
Yes.
Hey, hello, miss.
Hello.
What's your name?
Xana.
Xana, do you live here?
Yes.
Hey, did Megan talk to you earlier?
No.
Okay, does Megan live here?
Megan. I do not have a Megan that lives
Megan
here.
Mogan?
Maddie Mogan, yes.
Madison Mogan? Yeah.
Madison Mogan? Okay, she does live here?
Sorry, she is at the club. She's 21. I'm just going to bed. I have a couple friends over, but
Okay.
this is my ID.
Have you talked to Maddie tonight?
Yes, I have.
Oh.
She's at the corner club.
Okay. Did she tell you anything about anything that happened earlier or anything like that?
Honestly, not really. I've just been here the past hour.
Okay. Okay.
Just trying to go to bed.
Can I grab your ID for me? If you
Yeah,
were running her?
I'm not 21.
Okay.
My roommates are 21. I just came to go to bed.
We're not here to talk about the alcohol stuff. Okay.
She's actually like, I'm not 21. I'm not sure if she's impaired or whatever, if she's been drinking. But they're like, we're not here for the alcohol, is what the guy says. So maybe put her at ease a little bit. But it is interesting, they're at the club, they're having a party here. It just kind of gives you an idea of the atmosphere, which is how I think it can become relevant, especially to the defense's case in chief, as to what the atmosphere was like at this house, potentially people coming and going all hours of the night. Now, it's not 4 a.m., it's 12:38. If it was 4 a.m., I think that would make it even more relevant that everybody's awake. There's people over, there's people coming in and out, people out on the porch, she's inside, other people are at the club. But 4 a.m. is a little different than 12:38, even in a college town.
Okay, yeah.
But this is the second noise complaint we've had here tonight within 2 hours.
I'm sorry
Okay.
about that.
So this time it was the blonde gal and the guy on the back porch playing music. Okay. So
I sincerely apologize about
Okay.
that. I'm just going to bed.
Okay.
So.
So just so you understand, you could be getting a misdemeanor citation for this, which means you have to go in front of a judge and explain why you couldn't keep the people in your house quiet.
Okay.
Okay. We've already talked to Maddie once and told her the same thing. Okay. The only reason she's not getting a ticket is because she's not standing here in front of me. But I'm telling you right now, if we have to come back, you're getting a ticket.
Okay. So
And you will
I'm
have to
not
go
right
see a
now.
judge.
I'm fine right now.
You're not getting a ticket right now.
I'm just trying to go to bed right
Okay.
now. I mean, I understand you guys. You're coming here. I'm just going.
Okay. Well, understand that you're responsible for the residents.
Okay.
So whoever else is here, if they have a safe way to get home, you need to kick them out or
Okay.
tell them to come inside and be quiet.
Okay.
Because the houses that are on this hill all the way around here, we can hear you from clear down the road when we were coming up here. We can hear the music.
So that's interesting. Houses all up around the hill and clear down the road. You could hear the music. So the music could be really loud, or the houses could be really close together. And we've also heard that people around may have heard things the night of the murder. So that's interesting. Will that come into play?
Music.
Okay.
And that's
I'm so sorry.
where we're past the
about
point
that.
of having polite conversations, okay?
Yeah, I'm
Because
so
neighbors are being
sorry.
kept up, okay?
I'm sorry. It's just like
Is the blonde gal and the guy up there, are they roommates too?
I'm sorry. What?
The blonde gal and the guy that's upstairs, are they roommates too?
None of my roommates are home. I'm
Oh, okay.
in one home. These are all my friends.
Okay.
So do you understand 100%
I understand.
what's going to
I'm just
happen?
going to tell everyone get the sorry
Okay, fine.
or figure it out.
And I'm not saying that you got to tell everybody they have to leave, but I'm telling you, any outside music, any loud yelling needs to be done.
Okay.
Because we're not, next time you're getting a ticket.
Okay.
Okay. And if you get a misdemeanor citation, the university is not going to take kindly to it.
Yeah.
So not only do you have to go see a
completely
judge.
understand that I've never had to deal with this ever.
Yep. And we don't want to start now. I don't ever remember having come here. So I understand you guys are having to get together.
So maybe this will go as evidence the other way. This was the only, noise complaint issue, party type stuff that they had. Maybe. Because he doesn't remember ever coming out to this house before, and the university wouldn't take kindly to getting these kinds of problems. So maybe this was the one and only. Who knows? That's why this stuff to me is not really, none of these videos that we've watched today are very helpful in breaking this stuff down. But a lot of you sent them, a lot of you had questions on them. So I want to watch them and see if there was anything there. So we'll finish this one out.
But people have a way of
Yes.
taking the invitation and using it as an excuse to get out of control and be loud.
Advantage. Yes,
Exactly.
I understand.
Okay.
I'm so sorry.
It's okay. I just hope for your sake that your friends don't put you in a position where you get the citation and you have to go to court to defend yourself
Yes.
from your friend's behavior. Make sense?
Okay. Thank you so
Okay.
much.
You want to get a good phone number for her?
Yep. And just remember, the Dean of Students office probably will be contacting you about this as well, about student code of conduct issues.
Yes, I have it.
It's interesting. I wonder if they have
Of
You guys
course.
ready to go?
any student code of conduct issues. That's interesting if the dean does reach out anytime something like this happens.
Thank you so much.
Any questions?
No questions.
Okay. Make sure your friends don't put you in a bad position. Tell them it's
I
time to be
will.
done.
I'll go-
Okay.
There's like no one in there.
Yeah. It was the two that were around the back. We had to holler at them to turn the music down. So,
Thank
alrighty.
All right. So now that's done. And so now we will transition into the court documents that we're going to break down that people had questions on. And that will include more requests for documents, motion to compel, and what's going on with the non-dissemination order. So let's get into that. Okay. So the first legal document we're going to bring up here to look at together is the third supplemental request for discovery. And again, this is just what the defense is asking the state to provide. Standard lab discovery, biological testing case file. Please provide a copy of the case file, including all records made by each lab in connection with biological testing in this case, including biological screening, serological testing, presumptive testing, microscopy, and DNA testing, including statistical calculations. Please provide photographic quality copies of all photographs in the original case file. Chain of custody and current disposition of the evidence. Profiles uploaded to a DNA database in the event that the case involves the upload of a DNA profile to either local, state, or national databases. Please provide all documentation maintained by the testing laboratory. Documentation maintained by combined DNA index system, personnel within the laboratory, including profiles that have been identified as known males, not the defendant. So could this be anybody else? Is it connected to anybody else? How did you search for it? What did you search for? What did you find? My guess is the defense has some DNA experts of their own that's going to go through all the evidence the state has to see how reliable it really is. The data files provide copies of all computer data files created in the course of performing the DNA testing and analyzing the data in this case. Again, the state could object to some of this stuff, but I think most of it they are going to have to turn over. What did they get as far as DNA? How did they test it? Where did they put it in there? Who else could it be matched to? What did you do to eliminate those other people if they did exist? What is the statistical probability that it was somebody other than Brian Kohberger? Again, statistical calculations. Provide a copy of all that. List any software programs used. Reference the population and the allele frequencies used for the analysis. All handwritten or electronic notes pertaining to analysis. Now, they might try to keep that as work product. Preparation for litigation. Some kind of protected way that they do or investigatory tactics. National security. They could try to block some of this stuff because of those reasons. But in order to do that, you have to actually object, not just fail to answer. Electronic data files, documents, all input and operator selected parameters. So it's like, did you only click people that are like Brian Kohberger? Could this be somebody of a different race or a different gender? I don't know. Not a DNA expert. But what did they click? It's kind of like in the old days when they used to give a photo pack and it would be one Hispanic person and 5 white people and the defendant's Hispanic. Not fair. Communications. Please provide a and just that's how defense attorneys flesh that out. And that's how it became law and a way to do fair photo packs or lineups is because lawyers had to find out about this stuff by looking through case files and then fighting about it and objecting to it and having judges say, no, that's not right. So that's why we do this, to make sure it is done the right way. And trust me, regardless of what you feel about Brian Kohberger, regardless of how much you think he did it, and he may have, and he may get convicted, and he may get the death penalty or go to prison for the rest of his life, justifiably so if he gets convicted. But we want these rules and protections and standards and procedures in place to protect people that have been accused of crimes. One day it could happen to someone we know and we love, or ourselves. Copy of all communications between lab personnel and other parties with regard to biological testing in this case, including memos, emails, texts, recordings, phone calls. And again, some of that stuff I expect to be objected to. Standard operating protocols and interpretation guidelines. So this is important, especially when we talk about, like in the Murdoch case, how Harpootlian used to be a prosecutor and he knew this stuff backwards and forwards. They're probably going to have former prosecutors assist in this case, whether they're private or public defenders. And then also, most people become DNA experts or investigative experts like this after having a job in law enforcement. So they know some of the operating procedures, but maybe they want to know what they are now or what they are for this office if they worked in a different jurisdiction. Peak detection thresholds. Just all sorts of stuff that they're looking for here. What do they include? What do they exclude? Policies, software programs. Validation summaries. Please provide copies of validation summaries, internal validation studies undertaken to establish the interpretation guidelines relied on in this case. Laboratory personnel. Please provide background information for each person involved. These are some of the people that, become witnesses and we hear about them on the stand. Well, this is how they get their initial information. Their resumes, performance evals, summary of proficiency test results. Unexpected results and corrective actions for each lab person. Did they get bad results? Did they have to correct anything? Seems kind of specific. And again, they want to know if this has happened and they've gotten results that were bad or had to be corrected 6 months before and 6 months after this testing. Genetic, genealogy, testing, and search. All reports generated by any lab that conducted SNP testing on any sample in this case, including from samples where unknown males, not the defendant, were identified. Copies of all communications between laboratory personnel and any other person or organization with regard to this instant case, including letters, memos, emails, internet posts, press releases, and records of other communications. All documentation associated with any database search, including but not limited to, they mention them all. All documents related to any genetic genealogy search, included but not limited to the creation of a user profile, account information, automated search results, uploading of data, etc. All documents related to any of that. And the name and address of all persons found to have sufficient sharing centimorgans with the subject profile to be identified as a match in the report created in this case. So it's basically like anybody else that's connected could possibly be connected to. So they are focused on the DNA testing, the genealogy reports, how it got connected to his dad, how they got the DNA, who did the DNA testing, have they had any problems in the past, have they had to fix anything they've done wrong in the past, have they gotten in trouble in the past, we need their resume, are they even qualified to do this stuff? And this is what a lot of the cross-examination is based off of. And, you know, if you watch a trial and you wonder, how did they know this about this DNA test expert? How did they know they were reprimanded? How did they know they had bad results in the past? Something similar or not similar to the gathering and testing of DNA in this case. This is how. It is a long, drawn-out process with lots of documents, depositions, statements, things like that. Memos that you have to read through. Again, the blood spatter expert memo that Murdoch's defense attorneys found. It came in a document dump like this as part of discovery. That's why you have to ask for the right things. Because just saying, give me all the evidence, give me all the documents, give me even all the Brady material that could be exculpatory doesn't cover everything specific enough. You want to make sure you get everything that could possibly help or even hurt your client to know that it is there. Because just because it's bad for you doesn't mean you don't want it in discovery, because the other side has it and they know about it. You want to be ready. All right. So after, or when was this filed? Let's see. Yeah, so that additional supplement was filed on May 3rd. So this motion to compel discovery was obviously not on that information because you don't have to provide it in one day. But there is a motion to compel discovery that the defense filed on May 4th, the day after that supplemental discovery request. And it is based on the defendant's first supplemental discovery and second supplemental discovery. So the first one would just be discovery. The second would be first supplemental. The third would be the second supplemental. And the fourth would be the third supplemental, to be as confusing as possible. So they're talking about the middle two, that the state has not provided certain documents in discovery. Let's see what they have not provided. Number one, Mr. Kohberger requests an order for the state to disclose the following items included in defendant's first supplemental discovery request. Number 43, all body cam and dash cam footage from officers involved in the search and arrest of Brian Kohberger in Pennsylvania. They have not received the requested materials. So that's interesting. We just watched that together in this video. Maybe they have just the same edited version of what we have and not everything. They absolutely deserve that. It doesn't seem like there's even been an objection, but instead they just haven't provided it. Request number 49, all lab testing, including photograph and color diagrams and bench notes, including but not limited to copies of lab reports detailing the forensic evidence collection and analysis of items recovered at Brian Kohberger's parents' house, trash cans, and other receptacles, and Brian Kohberger's Hyundai Elantra. As of May 4th, they have not received the requested materials, and based on information and belief, these reports contain exculpatory information. Okay, so this is where some of the headlines were coming from. So, again, these lab results are something they asked for in the past with a generic question, like I said, but they've done a third supplemental request that we just read together that is diving deeper and being more specific, but even the generic request has not been complied with the state. And they believe it could be exculpatory. Now, what does that mean? Was it an unreasonable search? Was it an unreasonable seizure of the trash? And if it was, then the fruit of the poisonous tree would mean they can't use that stuff at trial against Brian Kohberger. Now, there's ways to get around that, like eventual discovery. Like they would have gotten to his DNA anyways. They had enough for a search warrant. And once they got a search warrant, they would have made an arrest. Once they made an arrest, they would have got his DNA. But those arguments need to be had, and it could be potentially exculpatory if some of this stuff was gathered as part of an unreasonable or unlawful search or seizure. Now, I don't know if that's what they're pointing at, but they seem to think something important is there included in the request number 49. ISP and FBI forensic lab results, including but not limited to lab reports 11 and 25. Again, same kind of deal with number 49. Now number 119, all notes recordings from all officers from Moscow Police Department. They have not received the recordings and notes from the interrogation of Mr. Kohberger by MPD Detective Payne. So it means maybe there is something. Is there a recording? Is there a note? Was there an interrogation? It seems like there may have been, which is very interesting to us. What did he say? Did he make a statement? Is there body cam footage? Is there some kind of interview? And this is in Moscow, not in Pennsylvania. Number 115, all police reports, audiovisual evidence, and any recorded statements related to Brian Kohberger's arrest and incarceration in Pennsylvania. Again, some of this stuff seems like they're requesting the same thing over and over again, but you want to make sure you don't give them any opportunity to say, oh, well, you didn't ask for this or you didn't ask it the right way. They have not received the materials. All reports, notes, recordings, and photos. Once again, you would think something as vague as this in the second supplemental request for discovery would be covered in all police reports. All reports and police reports. Police reports is more specific than just reports. Notes, recordings. Also, we have audio, video evidence and any recorded statements. That would fall under recordings. We've seen photographs multiple times here. Also, generally, photographs. They have not received the requested materials, and they believe that these materials contain exculpatory evidence. Now, if you want my opinion, as a lawyer who does some stuff like this and has done some stuff like this is kind of generic language. I don't think that they think that there is some smoking gun or the opposite of a smoking gun, some big deal exculpatory piece of evidence in the, photograph or recordings. I think there's a few things they think maybe were done wrong in the investigation by law enforcement, whether it was the search, the seizure, the warrant, something like that. To where they think if the state turns over all the recordings, all the reports, all the memos, all the body cam footage, all the DNA testing, that they may find something. It seems more generic rather than the state is trying to keep exculpatory evidence from Brian Kohberger and his lawyers. I'm not ready to jump to that conclusion just yet. Number 160, training records of specific officers. They have not received the requested materials. So requested time is 10 minutes for the hearing to make this argument for Kohberger to force the state to turn this stuff over. Now, the state can't just not do it. And that's annoying when that happens, in civil court or in criminal court. If they have an issue or they don't think you're entitled to that, file an objection, because then the lawyers can argue about the law and whether or not it's appropriate to get this or that, this recording or that memo based on your objection. But if you don't object, we don't know why you're not giving it to us as lawyers. And then we don't even know what to tell the judge. So the judge wants to know, what's your objection? That's how we're supposed to handle things like this. All right. Next. The next document we're going to get to is an order vacating and setting scheduling conference for motions, amended non-dissemination order. A motion to appeal, amend, and or clarify amended non-dissemination order and memo in support of motion for appeal and or clarification was filed by the Gonsalves family on February 3rd. A petition for writ was filed with the Idaho Supreme Court on February 6th. A memo of points and authority filed on February 9th. On February 27th, the court issued a notice regarding the hearing date. On April 24th, Idaho Supreme Court issued their opinion. On April 28th, the court issued a notice of hearing setting Gonsalves' motion to appeal. On May 25th, on May 2nd, the Associated Press filed a motion to intervene and a motion to vacate the non-dissemination order. So they got involved after the Gonsalves family already filed their stuff. So now the Associated Press and all the media is involved with the Gonsalves family, joining it together after they lost from the Idaho Supreme Court. Everybody is coming to the appropriate court now to ask her to get rid of this non-dissemination order or to amend it in some way so that everybody knows what they can and can't say and the media can have some more involvement. The Gonsalves motion and the AP motion concern the same subject matter, the amended non-dissemination order, and should be set for hearing at the same time for judicial efficiency. Yeah, let's come all argue it together. We've seen stuff like this before in the Lori Vallow case. Therefore, after due consideration, it's hereby ordered that the motion to appeal and amend the non-dissemination order scheduled for May 25th is vacated. It's further ordered that a scheduling conference regarding all the motions dealing with the non-dissemination order will be moved to May 22nd at 10 a.m. Any recording or live streaming of the Zoom is prohibited, so we will not be able to watch it together. Silly me for thinking that any moment in time could go by in this case without something new happening. So we just finished looking at the judge's order that was dated May 4th, setting a hearing on May 22nd. And it's not a hearing to argue about that non-dissemination order. It is to schedule the hearing to argue the non-dissemination order. So the judge has kicked out this issue till May 22nd. And then at that time, everybody's going to show up and figure out when we can get together in the future to argue about this non-dissemination order. Well, on the day I was originally recording this, May 9th, the media conglomerate was not happy with that order, and they have since filed a motion to reconsider that order and a memorandum in support of that. So we are slipping this in this part of the video to talk about this before we get to the last document that we're going to review together. It seems like something is literally happening every single day in this case. And there was, in fact, a motion to reconsider, and this is the memorandum in support of that because they say basically the same things. This is just a little more in depth. So that's why we're going to focus on this. And again, you can see the media conglomerate that is joining together and filing this, the same media conglomerate that filed their motion up to the Idaho Supreme Court and was kicked back to the lower court. And that's important context as we read this memo. With each passing day, the amended non-dissemination order dated January 18, 2023, the gag order, causes irreparable harm. At every step, interveners have acted quickly to vindicate their constitutional rights and to stop that irreparable harm. So they are saying that we need this done now because every day we wait is causing harm, is violating our constitutional rights, is violating the rights of the public. The Idaho Supreme Court similarly acted quickly on 2 motions to intervene and set an expedited briefing schedule. So we talked about how surprising it was how quickly the Idaho Supreme Court acted and responded to the media's motions and argument about this gag order. Respectfully, this court, meaning the lower court's decision to hold a scheduling conference, again, it's important that it's a scheduling conference, not the actual hearing, on May 22nd, 2023, instead of scheduling interveners' motions for the next available hearing date and following the briefing schedule set in Idaho Rule of Civil Procedure 7B3 and Idaho Criminal Rule 45C, adds at least 3 weeks of additional irreparable harm while the parties wait for a hearing date and a briefing schedule. So what's the issue here? The media thinks that this court is basically kicking the can down the road, delaying their opportunity to argue this. And let's think about how this goes. If this hearing is in fact May 22nd, that only leaves about a month until the actual preliminary hearing. So within 1 month, all these media companies, the lawyers, the defendant, the prosecution, the judge, all have to find a time they can all get together and argue this motion to get rid of the gag order or amend the gag order or clarify the gag order, including the victims and their families and their lawyers. So let's say if this took 3 weeks to schedule, just the scheduling conference, let's say it takes another 3 weeks to schedule that hearing. Now we're in mid-June. And let's say the judge takes the hearing and the motions and the arguments under advisement and she issues her order later. Well, let's say she takes a week or maybe 2 weeks to issue her order. Well, now we're into the June 26th arena and area where the preliminary hearing is going to start. And at that point, does it just become moot? If the judge does not find probable cause and it goes away, it's gone. The public and the media's rights have been trampled on potentially. Now, if the judge likely does find probable cause, then she'll have to determine or make a decision about this motion and this memo and this non-dissemination order and how it's going to apply to the rest of the case. But either way, the process that we're going through right now with the discovery, all the documents we're talking about in today's case, in today's video, or potentially even the body cam footage that we're talking about in today's video, all of that could be restricted or the comments on it restricted based on this gag order. And that is irreparable harm, at least arguably, by the media companies. And I'll talk about at the end what I think and what I agree or disagree with what they're arguing, but at least that makes some logical sense. So what do they propose we do? To avoid that additional irreparable harm, interveners, meaning the media companies, request that the court reconsider its order dated May 4th, 2023, and either do one of these things. 1, stay enforcement of the gag order pending a decision on interveners' motion to intervene and motion to vacate the amended non-dissemination order to avoid any additional irreparable harm while motions are briefed. So one thing that kind of annoys me is they put gag order here in parentheses. So they're supposed to call it gag order, but they keep calling it the non-dissemination order. But either way, they're saying first, if you're going to push us out 3 weeks and then even more weeks to set up the actual hearing to argue these motions, stay the gag order. Let it be open until you make your decision. Judge ain't going to do that. So what's number 2? Or set a hearing on interveners' motion to intervene and motion to vacate the amended non-dissemination order on the next available date on the court's calendar to trigger the briefing schedule in Idaho Rule of Civil Procedure 7B3 and Idaho Criminal Rule 45C. So that's a much more plausible option. Instead of waiting till May 22nd, when's your next available hearing date? We will show up. We will argue this motion. Or at the very worst, instead of scheduling a scheduling conference on May 22nd, let's just do the hearing on May 22nd and you make your decision on May 22nd. Even that would be better than what you have right now. And I just realized why it's probably not called the gag order here, because in fact, they are stating the actual title of a pleading, which is the motion to intervene and motion to vacate the amended non-dissemination order. So that's my bad for reading this stuff in chunks. For over 4 months, the court's gag order has restricted speech related to this matter without the court holding a hearing or receiving any evidence. The gag order violates the First Amendment of the United States Constitution, Article 1, Section 9 of the Idaho Constitution, the memorandum in support of the motion to reconsider the order dated May 4th, 2023. The declaration of Wendy J. Olson in support of the motion to reconsider. We're not going to read that together. That's just her putting all the exhibits and everybody that agrees with her, basically. Those are constitutional violations of urgent nature. Any First Amendment infringement that occurs with each passing day is irreparable. Even a short-lived gag order in a case of widespread concern to the community constitutes a substantial prior restraint and causes irreparable injury to the First Amendment interest as long as it remains in effect. Because each passing day inflicts additional irreparable harm, interveners have worked quickly to vindicate their rights. Within 19 days, which is less time than it's even like taking for this to get to the scheduling conference, or right about the same amount of time, of the court issuing the gag order, interveners organized a nearly 30-person coalition, retained counsel, and filed a challenge in the Idaho Supreme Court. So they all got together, they picked one lawyer or a main lawyer to lead and to file this within the Idaho Supreme Court. And that's true. That is a pretty quick turnaround to get all this done. The Idaho Supreme Court recognized the urgency of interveners' challenge, and within 3 days of interveners refiling their challenge to include a verification signed by the coalition members and not counsel, the Idaho Supreme Court ordered briefing on an expedited basis. And when the Latah County prosecutor and Mr. Kohberger moved to intervene, the Idaho Supreme Court granted their motions without full briefing and without modifying the already set merits briefing schedule. What that means is the Idaho Supreme Court looked at this situation and saw what they filed and everything that was going on in this case. And they didn't wait 3 weeks. They jumped on it like that. I even commented on it. If you want to go back and read what they filed to the Supreme Court, what the Supreme Court said, we did a video on it. It's in the Kohberger playlist. I was shocked at how quickly this was turned around in the Idaho Supreme Court. Now, it didn't necessarily affect their decision. The media company still technically lost, but really they were told you have to go through the steps. We think you might have a decent argument with this non-dissemination order. So if the Supreme Court can move that quickly, if all these media companies can move that quickly, why can't this court? On April 24th, 2023, the Idaho Supreme Court held that a vague, overbroad, unduly restrictive, or not narrowly drawn gag order would be an unconstitutional obstacle to the interveners. Now, they didn't say that this gag order was that, but they said if it was found to be that, it would be unconstitutional. But the Idaho Supreme Court denied interveners' petition because it held that a plain, speedy, and they italicized speedy, and adequate remedy at law exists. if interveners were to seek relief from this court, meaning the lower court that they're filing this motion to reconsider on. So something that's important to point out here. They don't even care, it seems like, and I would agree with them, if this court even has a hearing. Just make a decision, lower court, and make it quickly. If you're going to deny our motion, that's fine. We need an answer, because without an answer, we can't go to the Idaho Supreme Court. And we think the Idaho Supreme Court's going to agree with us. But first, we have to exhaust our other options, and you are our other option right now. But you are supposed to be a speedy option. So the fact that we're taking 3 weeks to even schedule this is a problem and not a speedy option. And I think they're filing all these motions, and if the court doesn't move up the hearing or doesn't move up the scheduling conference, then they can go back to the Idaho Supreme Court and say, listen, we tried. They denied our right. They denied our speedy remedy. We're stuck. We have nowhere else to go now except to the Idaho Supreme Court, which is something they could not have argued before, and which was ultimately the reason they did not get the outcome they wanted at the Idaho Supreme Court. So win or lose, the media conglomerate and the Gonsalves family and the victims, everybody wants to get rid of or modify this non-dissemination order. They all win if this court just makes a decision. Because if they make a decision and they win on this court, boom, they won. If the court makes a decision and they lose, they think they can go up to the Supreme Court now and win and have exhausted all speedy remedies available to them. There's a lot of legal maneuvering going on. Following the Idaho Supreme Court's direction, interveners took merely 7 days to prepare and file their motion to intervene and motion to vacate the amended non-dissemination order. Now, I'm surprised they didn't do it quicker once they got that motion back, or the order back from the Idaho Supreme Court. I don't know why they couldn't just basically copy what they sent to the Idaho Supreme Court. But the next day, interveners, after it took 7 days to prepare a motion and they filed it after the Supreme Court said they had to go to this court, the next day, interveners contacted the court to schedule the next available hearing date, which would automatically set the briefing schedule for the motions. Instead of providing a hearing date, and that's the other problem, the court should have just provided them a hearing date, and then they would have known the schedule of when everything was going to happen. So if it was going to be 6 months from now, they could argue to the Supreme Court, but they just don't know. Right now, they're stuck. This court is not giving them the information they need to make decisions. And that's frustrating. Sometimes that happens in cases when judges make certain decisions and they don't give specific enough facts to help us appeal that decision. It's just summarily granted or summarily denied. And that can be frustrating because there are rules in place that allow us to do certain things, and we have tools in our legal tool belt. So instead of providing a hearing date, the court set a scheduling conference on May 22nd, 2023. The court also vacated the May 25th hearing date for a related motion filed by the victim's family, which presumably is, or at least was, available on the court's calendar to hear that motion and intervener's motion. Interveners understand that a briefing schedule for their motions will not be set until after the scheduling conference. So what they have to do in the timeline of when they can do it's not going to be set until they actually have a scheduling conference set. And they're making another good argument that you already had a hearing set on May 25th. Why couldn't we just keep that and piggyback our motion right on top of theirs, which is basically the same thing? We all have a problem with your gag order. So the court got rid of that May 25th hearing, added a May 22nd hearing, but that's only a scheduling conference. That's not the actual hearing to argue these motions. And they make a great point pointing that out, because that does delay the process. Respectfully, it's always great when anybody, including a lawyer, starts out something with respectfully. Waiting 3 weeks from when interveners filed their motion to have a conference to then provide additional time for briefing, prolongs the irreparable harm inflicted by the gag order and contradicts the Idaho Supreme Court's holding that interveners could obtain a plain, speedy, and adequate remedy by refiling their challenge with this court. The Latah County prosecutor and Mr. Kohberger have already briefed the constitutional issues before the Idaho Supreme Court, and they are thus better situated than the typical litigant to satisfy the briefing schedule set in the Idaho Code and the Idaho criminal rules by the next available hearing date. Accordingly, interveners again request this court reconsider its order on dated May 4th and either one, stay the enforcement of the gag order until they actually have this hearing, which is not going to happen, or two, set the hearing at the next available date on the court's calendar to trigger the briefing schedule. Signed, Wendy Olson, who is the lawyer for the media conglomerate. So what do I think about this document? Well, I think they have a pretty good argument. Now, That doesn't mean they're going to win. That doesn't mean the gag order is going to go away. It's definitely not going to get stayed. I think the gag order is either going to be amended by this court or she's going to deny this motion, which is still a win for the media conglomerate because now they can go up to the Idaho Supreme Court where it seems like they had some kind of traction. I think the judge is inappropriately delaying this. Now, listen, I'm not blaming her. I'm not saying she doesn't have other things to do. All the court systems are clogged. Everything takes forever. But this is important. Irreparable harm is being done. If this gag order is in fact unconstitutional, waiting another 3 weeks or 6 weeks or the entirety of time before the preliminary hearing would be irreparable harm, in my opinion. Now, if they lose in this court and they lose in the Idaho Supreme Court, no harm, no foul. But let's at least give the media companies and the victims' families and these lawyers the appropriate legal remedies that are allowed by law. And again, that does not mean they're going to win. It just means they're allowed to make the appropriate arguments where constitutional rights are at issue, and there's nothing they can do to take back this time and get this information out to the public that they feel is incredibly important. I think a gag order is okay, generally speaking. We've talked about this stuff, but I do think it needs to be narrowly tailored and appropriate, and I think it's inappropriate to not allow lawyers for the victims' families to comment on things, especially if they're not giving away any secrets or litigation privilege or anything like that. They should be allowed to comment, my opinion, one man's opinion, but we will see what happens. And either way, I do think that's an unreasonable delay to wait 3 weeks just to schedule this, just to start the ball rolling when we are less than, 6 weeks? Less than 2 months away from the preliminary hearing. And just to hammer it home here with our last document, we are going to show the notice of remote hearing on May 22nd at 10 a.m. We will see what happens. The media is going to show up. The Gonsalves family is going to show up. The other victims may show up. It's about less than 2 weeks away from now is our next step in this Kohberger case with the non-dissemination order. So a lot of things happening right now. A lot of little nuggets, nothing huge. So what are your questions? What do you want to know? What do you think this indicates? What do you think this motion to compel is and the discovery issues that they're having? Do you think the state is hiding exculpatory evidence? I don't think they are. I think that'd be a bad idea. It's going to come out regardless. They don't want to violate Brady or Giglio. We've already had an issue like that come up with one of the officers that was investigating this case. We still haven't fully found out what that is, but maybe we will one day. So it's a really interesting time right now as we're gathering discovery. Oh, and there's one thing I want to hit at the end. A lot of people are asking, did the grand jury proceeding happen without us knowing about it and they're not even going to do the preliminary hearing? We don't know because the grand jury proceeding would be in secret, but if the grand jury indicts, there's no reason to continue going forward with the preliminary hearing. So what does that mean as far as discovery? Does it all go away? Do they not get any of this stuff? No. It means they don't have to have a preliminary hearing. The defendant is no longer entitled to that, but he will have a first appearance. He'll read what he's charged with from the grand jury. We don't know what evidence was presented in front of the grand jury, but the state presents evidence. They're even supposed to include some evidence that may be bad for them, but they almost always win at the grand jury proceedings. And then he would be indicted, but he would still be entitled to all of this discovery. The rules don't change. The fact that they're doing requests for discovery, motions to compel, none of that will change. The state still has to turn over recordings, still has to turn over exculpatory evidence, still has to turn over search and seizure documents, still has to turn over DNA testing and lab results. They still have to turn over all that stuff. It's still going to be part of this case. And Brian Kohberger, if he takes his case to trial, is going to need all that stuff. So none of that's really going to change. But I am here for you to answer your questions. So make sure you get them in the comments. Find me on Twitter and Instagram at Tragos Law. We're almost at 20K on Instagram. And as soon as we hit that, we're giving away some of the new Lawyer You Know merch from the new merch site. Hit the like button on this video on your way out. And if you've stuck it throughout the entirety of 3 videos and 4 documents filed in the case, a quick hitter update on Brian Kohberger. Thanks for joining me today. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the lawyer you know.